¿Qué tal? Muy buenos días. Yo soy Solenaro, soy
Good
curadora.
morning. I am Solanaros. I am curator of documentary archives of the Contemporary Art Museum at UNAM, and it's a great pleasure for me to welcome you to these conversations. This will be the last we have, although the encounter, the Patrimonio in the Beat event will continue in its workshop format until February. As you know, back in November, we had some public events where we collectively discussed different topics regarding digital preservation. This meeting has uh, resulted very interesting since it comes from a variety of perspectives and fields. And it has just been one of the first efforts, interinstitutional efforts to continue moving forward in this subject that professionally is of interest for all of us. Today we have the first forum, the first conversation panel, and later today at 1 p.m. we have the art, law, and digital preservation panel, which will be moderated by Professor González Mello. And in this conversation, we also have Irene Soria, Lourdes Padilla, and Silvia Salgado joining us. We are very happy that you were able to join us today. This is going to be the activity. I will give the floor to Professor Renato González Mello, who will begin the conversation based on different reflections and questions. And we will also have questions from our audience. We would like to suggest that you send over your questions using the chat feature for Professor González Mello to answer. He is a very well-known character in the arts industry. As you know, he's a professor of arts in the UNAM. He is also a researcher of the Aesthetic Institute since the 90s, and he has also been a professor who works in this field. He has also participated in different working groups and panels regarding reflections on the cultural heritage, the memory, and the responsibility of different agents. This is why we would like to thank him for agreeing to be here with us today to kick off this conversation on the legal terms, free culture, and the conservation, preservation, and the different problems that plague digital preservation. Professor Mello, thank you so much and welcome. Good morning, and I'd like to thank you. Thank you, Solenaro, Julio Garcia Murillo, and the team of the MUAC Museum for this invitation to participate in this event and the opportunity to gather this group of guests today to reflect upon and discuss a topic that is increasingly important. And back when we were getting this conversation set up, I remember thinking this is going to be a topic that cannot be covered in just one panel completely, but we want to attract attention to its importance and very large impact, not only in the academic activity of researchers and university professors like myself, but society at large. The digital preservation of cultural archives is a process that uh, has existed for decades in Mexico, although we often complain that is lagging, but it is a process that exists, one that is plagued of paradox because there are social and economic factors which have led to the massive digitalization of the cultural heritage in very unequitable conditions. And on the other hand, there is a strong trend to limit access, and such has been the case ever since the technology became relevant as it is nowadays. I would like to introduce our guests for today's panel. We tried to have a panel of guests from different fields. We wanted to talk about law, but not only the logical relationship between the different laws, but also of their action in society and its consequences in the world, and beyond uh, what the text of law contains. So as you can probably find in the website of this meeting, we have the extended bios of our guests. I will summarize them. Irene Soria Guzmán, who is an academic. She calls herself a feminist hack. And when I give her the floor, I'm going to ask her to tell us what this means besides other things. And she's also an activist of the free software and free culture movement. She has acted as an advisor for the Federal Telecommunications Institute, and she represents Creative Commons in Mexico. Lourdes Padilla Cabrera, and of course, the different guests have a interdisciplinary, cross-disciplinary background. She is a master of law, but she also specializes in copyright and art history. She has a wide body of work in terms of copyright, and uh, she collaborates with the Aesthetic Research Institute of UNAM in this field. Dr. Silvia Salgado Ruelas is a professor in history of arts by the University of Seville. She is a researcher of the Bibliographical Institute of Research by UNAM. She is a researcher in the Archives and Manuscripts Fund. She is a professor of the in the School of Philosophy and Literature. She participated in a legal initiative that arrived in Mexican Congress successfully. And she is also someone who has taken part in conversations surrounding this topic. Welcome to all our panel members. I appreciate you coming here, joining us here today. And first, I'd like to start with this reflection and some thoughts. Digitization processes have become deeper in, well, particularly because of the pandemic. I remember 10 years back, I was not in Mexico City. I tried to make strides in my research, and out of 10 books or articles that I needed, I would maybe find one. And today the ratio has changed. Today it is rare not to find what we're looking for in the internet. Nonetheless, this of course has come with some dissatisfaction and reluctance. I remember an editorial of a progressive journal in Mexico that had a headline that was I found pretty shocking at the start of the pandemic. Some of the books were already and unfortunately digitized. That's what it said. And this was shocking to me at the time because digital books at the time were actually the reason why many students were able to pull through this lockdown. Faced with the need for a lockdown, the academia and other social stakeholders began to produce and use a great number of digital products that were not used in the past or were not easy to access by the population at large. For those in the academia, I think this also, you must agree that this affects society in general. Although the pandemic has increased the use of digital assets, including a wider publication of relevant and diverse cultural archives, law does not always follow. Mexico has a general archive law from the year 2018, which had some rulings on the copyright and others, pretty detailed in some of the if its components. And some of these laws include the possibility to use technology, which has not been a criterion that has been used in a systematic fashion in the Mexican regulations, in the legal system of Mexico. So here goes the first question for this conversation. In your opinion, how far has the Mexican law gone in terms of conservation and publication of digital archives? I'm asking this question first. Let's keep an order following the agenda. Irene, Soria. Hello. Well, first of all, thank you so much for this invitation. It's a great honor for me to be here sharing this panel with, well, in this early days of 2022, almost at the end of January. A great honor for me to be here sharing. Just as Renato said, this is not a topic that we can exhaust in just one panel. We will need to continue the conversation until we reach an agreement for the benefit of everyone. I always like to introduce myself at the start of my presentations so that everyone can understand where I'm coming from in my perspective. I like to think of myself as a bridge between because I have both generated content. I also am an academic, but I'm also an activist of free culture and the conversations that we have been able to have with other with experts in law. I have been part of some of these, and so this is where I am coming from. So to answer your question, I'd like to do this from the perspective of practice. One of the issues that we need to take into account when thinking in terms of law, conservation, and all of the different aspects that surround these topics, the shock or the tension between what's written in the law and what actually happens in practice is very worth noting. Those who are in charge of the conservation or the studying of the arts, or people from the academia and content generators, of course, content creators. In practice, we often realize that a law, instead of promoting certain things, they become a barrier to these. I like, I really like a phrase that I have heard a professor of music express, which is that in law, in the legal texts, we have everything except the essential things. So it feels sometimes like, yes, the law needs to bring both elements together. So from the perspective of preservation and the ability to use a document without it becoming a legal problem, there is some misalignment between this possibility and the very tight closing or the excess protection of copyright. To me, this is an issue that requires a conversation. Intellectual property and copyright is based always in no. If you read the law, the copyright law, you will realize how it's full of what not to do. And this, in turn, permeates into the surrounding laws of digital objects. The nature of digital, the DNA, at the core of the DNA of digital, we have the exact opposite uh, possibility: sharing, creating copies, and not having something that is unique and allowing for greater access. So, in order to have a conversation based on law, we need to bring to the table not only attorneys. We cannot leave everything just to the legal experts. We need to work this from the academia as well, but also from those who work with this in the practice, the people who are there out there every day, struggling to preserve, conserve, and use the archives, which is something I would like to discuss later. The use of digital archives for audiovisual work, for instance. What happens with digital archive in Mexico when audiovisual field, for instance? These are just some opening remarks, but I'd like to hear my colleagues in the panel as well. Thank you so much. Certainly, in law, we often find that the no is the most common answer. We hear about what is not permitted more than anything. And of course, this problem has many different angles, since the conservation of cultural heritage, which began way before the digital technologies were invented, there were already some very difficult needs, difficult to meet. Some of these are uh, stated in law, and with the rise of telecommunication and digitalization, these became very difficult to handle needs. Silvia Salgado, when talking about this conversation with her, she told me about the Legal Deposit Act that I'm now going to ask Silvia to share with us about. Thank you. So before I move on to the definition of legal deposit, I'd like to join my colleagues in thanking you for the invitation and thanking you, Renato, for acting as a moderator and for this invitation to talk here today about art, law, and cultural heritage in a beat. A very interesting title for this meeting that has been organized since November, which has been very interesting so far in terms of results. So to pick up on what Irene Soria just talked about, the desire to have irrestrictive access to art and intellectual scientific creation, both present and past, there is something that is called a legal deposit. And this is a very important element for any country because it is part of what we as people, as human beings, need, which is to compile, to gather, to preserve, to organize knowledge and information that is produced in the nation by a nation. So libraries, national ones, but also public libraries in the case of Mexico, or some university colleges, etc., which disseminate, produce, and conserve editorial production of a country and everything that is written about the region of the country or in that region. So a legal deposit is a legal agreement that is signed and that it's embedded in the law. In this case, it was recently embedded, starting with the passing of the General uh, Libraries Act in Mexico in June of 2021. So we not even a year back. And this legal deposit was which in the past was a decree, uh, to have at least two copies in the National Library and the Congress Library. This has been extended into the Mexico Library, which is the Central Public Library of Mexico. And this new law considers legal deposit to include the digital format. So for the first time, we have by law the requirement, the obligation and responsibility of editors and creators of digital content to conduct to deposit in all three libraries mentioned. And in the case of a format that is the property of the national libraries and others, the Mexico library must necessarily channel these digital resources. These are no longer the bibliographic resources, but the ones that were already produced in an electronic fashion, which are then channeled into these two institutions that were born just last century. So the federal law of the copyright is restrictive because it must protect the right to patrimony, to heritage of institutions who create these works. But on the other hand, and if we read this law carefully, we see the possibility to access these through the issuance of licenses. But law also causes tension and has tension between different laws. So certain elements of harmonizing are necessary, both in the federal copyright law and that of access to transparency and to the protection of personal data. Meaning that, yes, there is a tension that must be discussed not only between lawyers. In the case of the general law of libraries, we had the participation of both librarians and lawmakers to find out the best way for this law to work. And I think I'm going to leave it here so we can continue with the conversation. Thank you. The law may cause some tensions and frictions or may try to resolve them and in turn cause more tensions. This is the social dynamics that law entails. And Mexico has been known to be a very legalist country in a variety of ways, and one of which is that our legal texts are full of content that would need to be promoted, that are in the Constitution, that have reached the constitutional status in the past few years, which are known as third generation human rights, which set forth different things such as new rights, the right to culture, for instance, which is in the Constitution. Of course, there are also legal ordinances which are considered as such, being part of the constitutional text that pose and impose limits and even some prohibitions, which require permanent interpretation task. And here I'd like to ask Lourdes Padilla, if, well, in your opinion, how far has Mexican law gone in terms of conservation and publishing of digital archives? But more than this, I want to ask you a bit of a technical question, a surprise question. I'm sorry, I forgot to tell you about this question, and please feel free to answer later. A change in the confirmation, a recent change in the confirmation of the legal system in Mexico provides a greater weight to jurisprudence, or this is how non-lawyers understood it at least. So seemingly now there will be a practice in courts which may help provide different nuance to the law so that these are more in contact with, or closer with the reality. So I'd like to ask you about your insights on this change of the legal system. Can we expect, or would it make more sense to try to go to court to fix or attempt to fix these problems that in the past only made us feel helpless? Thank you so much for the invitation. And Renato, I do agree with you. The one thing that we need to do is talk. As my grandmother used to say, it's only through talking that people can understand one another. And this is something that we need in this field as well. I fully agree with Silvia and Irene's thoughts on legal tensions. I believe that these tensions occur precisely because by adding a greater priority to the commercial elements, when different commercial elements like the test agreements, when it comes to the cultural components of it, there is a greater distance from the political tensions. And I believe this to actually cause further imbalance in the exercise of rights, which in turn causes inequality. We, just like you said, we may think that cultural rights are new rights, but copyright are part of these law, which are also in turn part of human rights access law. So if we could all understand at a broader range where it all comes from, perhaps the interaction of the different actors involved, the different stakeholders, would be more would be full of equity, which it lacks so far. As Silvia said before, law seems to be made to restrain or to cause constraints. But I would say that rather in Mexico, we have an exception to the monopoly, and it provides an exceptional access to this monopoly. But with this growth of commercial stakeholders, it would seem that the maximum protection is given to those who are benefiting or profiting, while instead we should be asking ourselves who is benefiting and how. And perhaps through these conversations, we may be able to put at the core what really matters, which is the democratizing of knowledge and culture. And I think what the pandemic has done is cause us to be left exhibited unnecessary protagonism, often also one that is based in abuse, and that in the past we have not really been communicating across stakeholders in this perspective. I also agree that the issue with having lawyers at the table only is that they only know about law. And this is something that shows in the interpretation that is made of law. And I agree, we do have a lot of law happening. I would expect this activity to be one that is more uh, of needing, of creating links. Irene said she likes to think of herself as a link. Although I am a lawyer, I prefer to think of myself as someone who works from the perspective of activism, feminist activism, and human rights. My criticism to law comes from even from the way it is taught. I think in my case, I like to always speak from these two perspectives, but also from one of dissidence. When we talk about lawyers, it would seem like we all are part of the same industry and we all agree with each other. When the truth is, we often dissent with this predominating discourse. When the instead of speaking of convergence of rights, like you well said, there's a convergence of freedom of speech, access to information, right to culture, copyright. This is more presented as a coalition. This is part of this removal of the political aspect of it, facing one another. And from my perspective, it should be a tool. They should become not protagonists, but facilitators. And we need to change any other perspectives. Latin America and Colombia, two organizations, Latisoc and Charisma, created a report known as Flexibilities of Latin America, a very powerful and educational report where, from the perspective of a map, it was analyzed what the flexibilities were, known as limitations and exceptions by the Mexican law. So a map like this allows us to understand what the flexibility to copyright really is in order to conduct a in-depth review of everything from the academia to journalism, etc. And looking at this chart, it becomes obvious how in Mexico, despite all the law we have, we are yet not yet ready. And in a context such as a pandemic, this is a problem. We are not doing this right. Ecuador is the example, starting with Correa, a very important component of the right to culture was included, which shows in its law all the different possibilities uh, that are out there to be able to exercise this right, as mentioned by all the international treaties, to participate in the cultural life. And all the creators are part of popular life by creating, but also those who enjoy these creations, the users, even known sometimes as consumers, they also have a right to access culture. So I'd like to end my participation here to be able to hear other colleagues. Renato, you're on mute. Sorry. Yes, something important to consider here is the interaction of different legal systems from different national traditions. And this is especially evident in international agreements such as the free trade agreement in North America and other things such as the Creative Commons documents. I remember not long ago, perhaps Lourdes will remember this, there was an event, it was a presentation of digital books, which had the Creative Commons logo, and institutional lawyers in attendance almost had a heart attack. And so was the audience. It was a moment of shock, which fortunately was overcome quite fast. But Irene, how far has free access or open access progressed in the case of Creative Commons, for instance? As I was reading this question, I was trying to compile not only our experiences, but also the work that has been conducted from Creative Commons as well as others, such as Wikipedia Mexico, which has been an important group, an important coalition, which has uh, it has been a whole wave. I'd like to be more optimistic, but part of what we have been dealing with, or the main obstacle, I believe, to these topics has been fear. When you talk about law, for instance, usually Creative Commons comes to play, but neither of the six licenses of Creative Commons intervenes with the law, except for the number zero. So we have had to become a bridge between those who do the practices and institutional lawyers. We are lucky that younger lawyers are a little more open. This does not necessarily mean the older ones not, but it has been a constant struggle to set the examples of other countries and how Creative Commons licenses do not counter the law. And these are just a way to reach an agreement. Although they do come from free software, but they are planned by lawyers who are also based in the agreement and the signing countries of this agreement. So these do not counteract the copyrights. These are just a label to reach agreements across different countries. One of my colleagues in Creative Commons says it, uh, uh, describes it like this. I challenge you to try to translate the law, or for someone who is translating the law into Chinese or any other languages, to try to show the details of each law. So to answer that question, I think there's a lot missing in this sense. I think we have been doing this in the last years. We have tried to promote this from a practice. Just read the texts of the National University UNAM. There are disclaimers. You can use it provided that this. That is what Creative Commons do, the licenses. They all have, all six of licenses or six possibilities for licensing have attribution. They all uh, state some conditions. So in our case, we have, well, conversations, discussions, considering them an instrument more than the end, an end, but rather an instrument of use where there is a lack of agreement. We suggest an instrument that has worked in other spaces, in other places, and that is just like a label to grant permission, provided that certain conditions are met. Something that happens already with several archives, such as Prelinger and several others of the National US Congress and others. I don't like to set examples of the global north, but often it would seem like these are very valuable in certain spaces. They seem to be more underscored. But I do believe that it is possible for us to have a dialogue, for this to become a way or an instrument to release some of the tension and try to level the ground again, like Lourdes said, to politicize the subjectivities and individuals for this to be more than just an intermediary or just adding power to companies or trying to homologate what's happening in the US, Canada, and Mexico, specifically for copyright, may result in some disadvantages. We do not work in the same way. We do not have the same history behind us or the same perspectives or anything like that, the same cultural practices. So there's no way that we can function in the exact same way. So I think a lot is missing. We are still doing what we can. We're just a group of volunteers. So I believe the great challenge will be to stop being afraid, to stop being afraid and to remove some of these restrictions. This has been used for a really long time, and I think in Mexico we're still lagging a little behind. But this also requires a lot of activism, I believe. Thank you. So I have this question next, which I've heard frequently. To what extent do you believe that this conversation on copyright, I think most of us who are discussing these matters here, perhaps, of course, do not want our rights to be vulnerated. However, when talking about open access licenses, Lourdes, perhaps you can provide some insight here. This is something I'm not familiar with. Perhaps what's causing a conflict here is this assumption that a document which is not strictly um, one that is sanctioned by the law may cause a legal obligation. And this is actually just part of the history of right and of law, for law not to become a monopoly. However, a license, a Creative Commons license, is not really a law that is sanctioned by the state. And perhaps there is something else, something deeper in the lack of comfort that documents like this may pose because they come from a legal tradition where the president can be anywhere and not just in the uh, higher states of law. I agree with Irene. I think fear is what may help these tools, such as the Creative Commons tools, and generating agreements in their use. In fact, I think the last reforms are even dissuasive in nature for users. I believe this further adds. So, in general, when we speak about law and we speak of lawyers, most of us think of conflict and think of something that we don't want to get involved with. This is the mistake we have made, every one of us. I believe that this requires some insight. We need to understand that this is a matter of appropriation of our own rights. This is a way that fears can either take their right um, dimension or go away for us to feel more confident when signing a contract or requesting a license. In my experience, when you approach people, they are willing to understand you and listen to you. And so also these licenses can be used, the Creative Commons licenses. I believe the state has the obligation to promote human rights in general. That's one of its main obligations. And I think, from my perspective as a professor, that is the most important but less visible thing. So many other things seem to be relevant, but not having the citizens obtain the necessary tools to understand these legal frameworks. These are also part of our everyday lives. Students who want to use a certain picture in their thesis and worrying about whether they'll go to jail or not for using an image. In the uh, international law needs to be as one that provides reconciliation and not punishment. And when this became invisible, I think this was when we began uh, putting more weight on avoiding piracy and adding punishments. And the criminal component of the law became bigger while everything else remained static, as if society had not evolved at all. It would seem like the only thing that we care about today is avoiding piracy. But let's not talk about what piracy is, even with the creators themselves, what they consider piracy and what not, uh, to try to fight all the fears that relate to it. And for the law to promote these instead of dissuading them, I think that's what I have learned so far with all my years of living or of working with creators. The fact that copyright is requires an increase in the awareness of the great efficacy that mediation mechanisms have in the event of conflict. It's not all just lawsuits and teams of lawyers and all that. However, I think this misalignment between access and restriction becomes very acute in the digital world because of the ability to access the internet that the world has nowadays. However, this is not really something that new. This mismatch between access and reserve is something that archives, digital and and uh, and paper have had to deal with, something that was evidenced in this recent conversation of the general archive law. This was very important. And Silvia, you have been involved in some of the conversations concerning issues like this. What would be your thoughts from the perspective of the National Library, for instance, or from an experience that may seem one that is relatively distant on digital technologies, as is the case of this research work on colonial codex? And just as these topics quickly lead to an issue of human rights, the interest in old ancient documents so do it too.
Sí, estoy de acuerdo. A mí me parece que voy a intentar regresar
I
al
agree. I will talk from a different perspective, and I would like to have this last intervention be about the concept of heritage, which is at the core of everything we do. And museums and other places of conservation and preservation of the intellectual and artistic production. And one of the ultimate purposes of these institutions is to provide access to facilitate the coming together of users, readers, and the audience in general, which enjoys the work, allowing access both in a digital or analog manner or through a catalog or interpretation. I believe that we are responsible, all of us together, but especially institutions, to uh, come up with digital preservation plans, because unless we become organized, we will be providing uh, a digitalization practice that is not accessible. And we need for it to be accessible so that it's not a whole body of uncontrolled information. So either old or new heritage requires a digitalization process, and we must analyze the need to do it in an orderly fashion to avoid just becoming saturated and uh, otherwise there is no way, we don't have the ability, the capacity to access such a body of information that we are trying to achieve. I believe that heritage, cultural heritage in a beat is the way to go nowadays. And I'd like to make reference to the UNESCO Charter on the presentation of digital heritage of 2009 that acknowledges digital heritage where we have obsolescence happening day by day. This is all part of the cultural heritage of the world. And an activity like this is not enough to make this information available, but we do need to have all together to think about the best ways to preserve this heritage. Preserving this heritage, the digital heritage, is harder. It is more difficult for codex to last for centuries than a beat to do the same thing. So this poses a problem, one that I believe is up to all of us together to solve. Renato, you need to unmute yourself. My last question before moving on to questions from the audience, and in a very brief fashion, if you had the ability to propose any improvements, either in the legal uh, practice for the improvement of this relationship between a heritage, copyright, the right of the public to culture, what would the suggestion be? What would be the law and the way to intervene? the international treaty, where does emphasis need to be placed? That is one of the questions. Let's start with
Sí,
you,
sí,
Cynthia.
cómo no. Fíjate que en aquella
Of
experiencia
course.
que tuve de la reforma del decreto de depósito
At the
legal,
time of
después
working with the
recientemente,
legal deposit
discutiendo con
reform,
los
which was later
varios
passed as a law,
abogados,
and
alguien
discussing with the
mencionó que era muy
experts from the
importante
Chamber of Deputies, someone mentioned
además
the
de desarrollar
importance
una ley, al
that
momento
it has when
de
a law
legislación,
is drafted
siempre hay que tener el
to
concepto o
always
la revisión
have
del impacto
the
económico que puede
vision
tener
of
esto.
the economic
Y la
impact
verdad
that
es
it will
que
have
eso no se
very
tuvo en
present.
el
And I
caso
believe
del
this
acervo
was not the
archivo.
case
Se presentó un
for
paquete
the General
un
Archive
sistema
law.
nacional de
A
archivos
national archive
enorme
system
pero
was,
no se
and it was
pensó
a
en el
very large body of
presupuesto.
work, but the
Entonces,
budget was
el
not
hacer
taken into
leyes,
account.
llevarlas a
So
cabo sin
to draft a law and to make it
elemento
happen
económico,
without
económico
considering the
presupuestal,
economic factor and the budget
físicamente
factor, I
hay
believe,
problemas
causes a great problem.
no solo de armonización y de tensión,
And
sino
this
de
is not just about
fragmentación.
harmonizing,
Y
but
pues
also of
agudísimos aún
realizing the law, which
por
causes
muy buena que esté la
gaps
ley, no se lleva a
and
cabo
a
de
lack of
manera
compliance. And
consistente.
no matter how adequate the law is, it is not, does not have the
Ese sería
economic
mi
foundation
participación.
that it requires to become actually useful. Thank you, Silvia.
Justo
Lourdes?
escuchándole se me ocurren, se empiezan a abrir un montón de vertientes y
So
recuerdo al
I'm
inicio que decían que
thinking of many different
en un espacio no agotas esta
perspectives.
conversación y sí,
Someone said
justo
today
mencionaba,
that
pienso un poco
just one
como
panel is not
de lo que
enough
habla Silvia,
for a
algo
topic like
cruza
this.
por cómo está diseñado el sistema
And
económico.
I
Las
agree.
personas que
This also
aspiran
relates to
a,
the how the
a
economic
los 6 meses
system is
que lo
designed.
adquiriste,
These
eso
laws
también tiene que ver con contaminación
actually
y
become
demás,
obsolete only a few
dificulta incluso
months
la
after they have been
preservación, ¿no?
passed.
Donde hay hasta vertientes
This
que hablan de
complicates
para
even
preservar
more
no
the
tienes que tener un
preservation.
dispositivo, sino tendrías que tener
In many
pues
cases,
un protocolo y un programa
uh, this
para
requires a
saber si está o no en
protocol
el dispositivo,
for
si está
the
o no están, ¿no? Pienso un poco en
preservation.
la pregunta que haces, Renato, y
So,
para mí, y lo vinculo con lo último que dijo Silvia,
Renato, and I'm going to try to
bajo el
link this
paraguas
with the
de
last
los
thing that
derechos
Sylvia said.
humanos
For me, the
de
human
hecho eso ya
rights
está
that from
dentro de la
2018 has been
Constitución, porque
implicitly included in
una
the
responsabilidad que
Constitution
tiene el Estado es
matters. One of the main
cuidarlos
obligations of the
al
state is to
máximo de su
protect and
autonomía.
study them to
Entonces,
the greatest possible
esto
extent and
demanda estarse
resources.
pensando cómo
And
hacemos
this
un
would
ejercicio de
require, of
armonización de
course,
todo tipo
considering
de legislación.
a way to
Y es
harmonize
por esa
all the
parte que,
different
como bien
laws,
decía Silvia,
always taking into
que
consideration
alcance para todos. Y
the
la otra es que
that this needs
esta es una
to be enough for
legislación
all. On the other hand,
progresiva,
human
de
rights are
hecho,
progressive
seguirá
as well.
siendo
So they
bajo
need
el
to
paraguas
continue
económico.
growing and not be
Esto
limited
implicaría
at
que los
any
presupuestos
time.
tendrían que ir creciendo al mismo
This would
tiempo para
mean the
que
budget needs to grow
pudiéramos tener este desenfreno
with it so that
en
this
algunos aspectos
exercise can be
del
fulfilled.
país.
In some of these
Pienso que
spaces, in
todavía
some of
no.
the contexts of the country,
Entonces,
this would
creo
seem like a
que
fantasy, but this is
desde
the
el lugar en
case.
donde yo me paro es, yo empezaría a
So
hacer
from
un
my
ejercicio de
perspective,
armonización
I
cuyo
see
marco fuera
a need for harmonizing
estos derechos humanos
from the
y que
perspective of
después
human
ir
rights.
hilando
And from that perspective, to
cosas
continue
que
to
se vayan
thread
clasificando en
together
estas legislaciones
all
en
the
beneficio
different
de las
aspects of the
personas,
law for the benefit of the people,
creadores, usuarias y demás.
creators, users, and
Me quedaría
others.
con eso. Muchas gracias.
I would close with that. Thank you.
Sí, yo pondría en la mesa el
Irene?
mensaje que yo
Yes, I'd like
siempre he creído que falta y es el de la
to
disidencia
say that
tecnológica.
something that is
La
always
razón por
missing
la
is
cual
the
es tan
technological
caro también preservar cosas es
advocacy.
porque seguimos confiando en la
We continue
centralización de
to
empresas que lucran
trust in the
con
centralizing of
códigos cerrados
businesses
y
that
traiciona el software
have
que estamos
do
realizando.
not
Para ser más
understand the
joven,
software that we
por eso
use.
también
We
es
are
mucho más caro
outsourcing
porque queremos
everything.
el control
This
de
causes it
los
all to
archivos.
become more
Esto ya ha pasado
expensive
control y
I like to not use the word control and instead use care. We'd like to change the narrative behind it. So, and this is partly my conclusion. This is something I have been studying for 10 years, and I propose activism. There is a whole wing of technology dissidents that has been around from the very beginning of the internet and the digital world. And I believe that all of this, including the preservation and sharing and everything that is bringing us to this point today, is inscribed in a framework of digital and tech capitalism. What if we were able to find new perspectives? We were not afraid and we could imagine different worlds based on the use of things that would seem to be, to cause a lot of fear, which in the end are all about returning the power to the people and decentralizing the decisions on what is preserved and what is accessed or not, as well as who decides on the archives and what is preserved. What group of people are doing this? What if the possibility was suddenly open to letting communities decide what they want to preserve? And for this purpose, we need autonomy. I always think of hacktivistic practices for this purpose to try to find a hack, to try to hack the whole situation, one that's keeping us in a square that never ends, a square loop that never ends, because we need to think of decentralizing and the DNA that at some point the internet fell victim to as well. This is one of the reasons why we are here today, because of this possibility to decentralize. So what if we lost fear of this and we all became the guardians of this? I just want to leave you with that thought. There's a whole wing of tech dissidents with people who are using free software, using non-privative codecs and other mechanisms which are not Google or Facebook
a empresas privadas.
or any other private parties, but who are rather trying to do this from a perspective of dissidents based on human rights, which is something that hacktivism also does. But this is also a whole topic that would take a long time to exhaust. Lots of things to say, lots of anecdotes, but we're running out of time. So I have a question from the audience. We have a couple of questions from the audience. The first one is very practical. What was the number of this Colombian organization that maps the flexibility of copyright? And could you maybe share the link with us? To have access to this resource would be very, very useful. This is the link. Charisma and Datisok are the names. I'm sharing that in a moment. It's a forum on flexibility in Latin America. Thank you. Someone from the audience is asking a question, the one that resonates with me personally. I don't want to discuss this at great depth. It's something that we've been going through for a couple of years, and now we finally see a solution in the landscape. But there's a question here. I think it's an interesting question for everyone. What tools or strategies are available to avoid the literary production from being affected from being able to promote or provide for the possibility to publish something, but often access restrictions, and fortunately, this is not very frequent, but they may become an obstacle to the research itself, to the publication and often to the publishing as well. What are the legal tools of a young academic, someone who has just recently graduated, who has a thesis work, who hears people saying, no, you cannot do this, you cannot do that, and how to mediate here? What are the alternatives that someone like this in this situation should seek? Lourdes, thinking about this experience, you mentioned the people who come to you desperately asking if they are at risk. Well, first of all, it's important for you to know, no, you're not at any risk. It's not danger. I'm sorry, I have some background noise.
Ya, perdón.
I hope that's better. Thank you. So yes, first of all, no, you need to know that your academic work is part of the culture building for
cómo lo voy a hacer y hasta dónde voy a llegar. Y en función de eso, de responderse
and based on these questions,
tener intuiciones de decir, aquí sí debería de pedir permiso.
to know by intuition where
Etcétera.
and when I need to ask for permission. Irene mentioned Wiki Commons and Wikimedia, which are also tools that must that are that help acquire material that is not subject to copyright, so that they can feel more confident to ask about the terms and conditions of usage and respect them. The first recommendation here would be to have a dialogue with the people who will be facilitating the material and and I think everyone will make mistakes in our academic practice, and there is a network of people who can help you and accompany you.
Aumentar algo, disculpen la interrupción, pero creo que sí, además de abonar bueno, de estar de acuerdo con lo que dice Lourdes, de buscar algunos de estos
I agree with Lourdes in the need to find some of these cultural digital assets that have broad licenses for use permission. And reflecting upon this need to find material and for them to release this material as well.
De esa misma manera obtenemos más beneficios.
And this is the best way to obtain more benefits by understanding clearly and setting clear examples of what is to be done with our work. And this is the way that sciences are built, culture is built, art is built. They don't just spring out of nowhere, and we don't work in isolation either. I propose the Creative Commons license as one of many options that are used around the world. Several of these very interesting, often appealing to non-capitalistic use with collaborative licenses. And I'd like to take this opportunity to let you know that from Creative Commons, we are very open to a dialogue and to conversations with your lawyers as well. We have our own lawyers too. And to artists, academics, researchers, young people, and not so young as well. We are not going to be without a job or money, and our copyrights are not being violated. We are just appealing to arriving at agreements between peers, and if we understand that internet works like this through mentions and through links, the symbolic capital that our works attain will be much greater when it is shared than when it is left in a repository and behind closed doors. Our work will be made known when we release it to the public. Just Google yourselves and let's see how often you find yourselves mentioned. So let's not be afraid because really nothing bad comes out of this. There is a question here. And I'm going to have to play the devil's advocate for lawyers who work to protect an institution and who often try to avoid harm to the institution based on a legal conflict. The Mexican legal tradition and instruments may be insufficient, particularly those that are the more traditional ones, in providing this legal certainty to an institution that publishes or that has or that takes care of the legal heritage. And however, I think if there was a way to access a tool and a manual, because of course, private organizations are involved too, which in the end are public in the way they act and who have very strict legal departments. So, and this these guarantee communication with users and others. So for this purpose, we would need to have a set of tools for those who are in the front lines, who receive a communication that they cannot publish any of their work. So instead of having to spend a whole month browsing online and trying to find who said what and trying to reconcile these two words,
Yo creo que dos cosas.
well, two things here. I think just as Irene said, Creative Commons licenses are a tool. They provide an option. But when the legal entities, the legal departments of these institutions are close themselves to these opportunities, my answer has always been make your own licenses based on your own guidelines and the way that you interpret the law. Make your own license in a way that it's more accessible to you. And just as Irene said, if these resources are not accessible, they are dead archive. And these institutions want for their archives to be alive. And this requires the enjoyment of the work. And this way, anyone can access them, benefit from them. This last part about the manuals, this was something that happened to me once. And what I did last time was write a manual to provide a cultural promotion. Every year, new interns come with the same questions as previous generations. I think what works best is to have a manual for when the new service providers arrive to study the manual and have fewer questions. This is a way for them to become empowered and to know when they can knock on doors. I think these are very useful practical instruments,
o hacerlos
and it would be
cambios
ideal to broaden them to broader fields. So internal manuals and institutional licenses. An institutional lawyer, far from hating it, is going to actually like it very much, because this is a way to normalize institutional work. So we see some questions about the protection technology measures included in the federal copyright law. And I also have some questions on NFTs, but we are running out of time. And the moderator has to do things that are not moderated at all in nature, such as closing a panel. I'd like to thank our guests, Silvia Salgado, Lourdes Padilla, and Irene Soria, for joining us here today in this panel. And yes, for joining us today. Any questions that we receive from the audience later, we will forward to you to answer them in writing. And once again, I'd like to thank the MUAC and the organizers of this activity. And we have some final thoughts on something that Silvia said, which I believe should be taken very closely into account. In Mexico, we have a wide experience creating institutions with objectives that are wonderful, and that for many of us in attendance, if not for all, it has become a calling to serve an audience. But institutions like this cannot just act out of goodwill. They need a budget. The tasks they have today imposed on them, there is no law demanding everything to be online in high resolution. But if you ask your audience what they expect of you, of your cultural institutions, you will realize that that is what they are demanding. And this is not easy to solve when we don't have the resources available. So financial feasibility of public institutions is an additional topic, one that must come together with the law for any future experience. I would like to thank everyone who has been watching this broadcast, and anyone who watches this in the replay, and thank you. Good afternoon, everyone. So before we close, I'd like to thank Irene, Lourdes, Silvia, Renato for this conversation. It has been very stimulating. I feel like I'm walking on warm sand. It's enjoyable, but it also burns. We need to continue working in a collective way to provide create awareness in a broad way. So I'd like to see this happen, as Lourdes said, harmonizing and working all together as a collective, not in silos, to add to the professionalizing and extension of the education and best practices. I was thinking about the restrictions of digital archives and how some users have abusive practices of them. So we have a need for good practices, from those who request to those who manage them, to those who are part of the thought process. We were not able to talk about piracy, which is part of the reality, and the ethical limits of when we promote it or not. But this is a topic for some other time. Let me just remind you that this is an effort from the MUAC University, a museum with the support of many colleagues and many institutions, the Tecnológico de Monterrey, the Instituto de Investigaciones Estéticas of UNAM, the School of Arts and Designs of UNAM, the National School of Conservation, Restoration, and Museography, the National Library of Mexico, and the General Directorate on the Digital Repositories of UNAM. And just a reminder that everything that the Heritage in a Beat has brought with us is in the microsite Patrimonio Beat in the UNAM site, where you can see everything that's happened so far and the panels to come. We have one more panel at 1 p.m. From the Digital Preservation Group, moderated by Alberto Castro. And there are still 2 more workshops coming. So just a reminder, open for subscriptions, one from Modera School and one about new approaches to conservation of digital work by INCRIM. Thank you all, and those of you who joined us today, and let's continue working all together. Thank you. Good afternoon. And thank you to the team.